Anything else? Yep.
My name's John Tengström, and I wanted to tap into your legal experience, if I can.
Okay. I'm not going to give legal advice, especially when it's being broadcast all over, but go ahead.
You can try.
Okay.
One of the questions I wanted to know is that when you're doing a startup, how important is it to protect your ideas and the things that you want to conceptualize and have people develop? For example, if you're hiring coders, to have them start building the actual product. How important is it to actually, through legal documentation, protect all that?
I think ideas are next to impossible to protect. It is the execution of the ideas. For example, just because I have an idea, I cannot copyright it. It only becomes copyrightable once I've written it down. I've expressed it in a repeatable way. Okay, whether I've read it on tape, I've recorded it, some way of recording it, some way of taking an idea and putting it on paper. These things can be protectable. Just a concept or an idea is not something that you can protect very effectively. And overly concerned, I would not be overly concerned about protecting things in the beginning because you don't know yet what you're going to do. However, I pointed out on one of the slides in planning, you need to think through where will the core of your competence be and make sure that core is protected. The easiest way to do that, when you talk to partners that you're sharing this information. For example, you mentioned specifically hiring programmers. There is absolutely no reason why you would not use an agreement. I mean, there are free agreements on the internet. Just use a consulting agreement, and that will have all the basic points of probably of confidentiality, non-competes, things like that in there. There's no reason why even a small startup does not use a simple 2-3 page consulting agreement, which makes it clear, hey, if you're designing a logo for us, this is a work for hire, it is for us, we can do whatever the hell we want with it. The moment you hand it over and we pay your bill, it is ours, you have nothing, you have no rights, okay? Because you're buying it from them as a work for hire. If you don't want to buy it like that, make it clear, hey, we're doing this, you're going to get 10% of the company shares or whatever. But whatever you're paying, make it clear where the rights are. I think that's simple. That's a non-disclosure agreement, NDA, 1 page. You can get by easily with 1 page. Or with that, I would use definitely some type of a consulting agreement. So it's clear that I am buying from you for money, and you will give me the work product when I pay you. So that's obvious from the legal agreement, because that is an area where people forget, and then 2 years later, they can't even find the guy, and they have no way of verifying who really owns what.
Couldn't you be also asked the question by an investor sometime later on, like, how have you been protecting this idea?
Not could you, it's just a question of when. It will for sure, a VC will go through your IP strategy. You will have to outline all the steps you're doing. You will show, if you're smart, you will have a whole presentation about, well, these are the agreements we sign with our employees. These are the agreements we sign with consultants. This is the non-disclosure we use. This is how we control IP within the company. We use this kind of encryption on here. You can only log in like this. You know, I mean, you'll have all of this outlined. Anybody that invents something that could be a business method in the US, we have a form for filling it out. You know, so that you show that you have a strategy, you have a plan. It isn't just by accident you end up filing something or finding something, that you have a method that you're actually following through on this. And examples of that can also actually be found on the internet for free, just an IP development strategy.
The reason I asked you all this, you probably know that Microsoft, Nokia, and Aalto University are working now together. They're putting in about 18 million euros over the next 3 years for the development of the Microsoft platform. But it also allows other platforms to be developed, just that you have to release the Microsoft, you have to let Microsoft have 6 months lead before you release anything else. But what some of the Finnish teams have told me is that there's a lot of involvement of students in other projects. So I'm just kind of concerned about the musical chairs syndrome, where they're involved in more than one project. They see interesting things going on in one project, and maybe take those ideas over to somewhere else. So how do you protect that idea? Because I actually believe that the quality is more important than the quantity, and I think that should be the focus. That if you have some summertime free time, you should be focusing on one specific single project and put all your attention there, and not sharing ideas of the company that you might be working for. So that's why I want to really get your thoughts about protecting that idea, and like you say, protect it through agreement.
Again, we have to be careful about defining what's an idea, right?
I mean, actually taking like if you have a Microsoft Windows app that you want developed, that's fully functional and does everything that you want it to do.
That's already more than an idea.
Well, yeah.
Right? I mean, this is already some type of a project or a widget or a demo or proof of concept. Yeah. But this is a little bit more than just an idea. Ideas are generally not protectable, okay? Just a thought that you have, right? But when we're talking about code already, you've got copyright that applies to that automatically. You've got database rights. You have legal rights that will attach to anything that you begin to record and type and express on paper. I think there is an interesting area here in law. I know that some countries, I can't remember exactly, was it Sweden one of them? This might be a case where I think in Sweden, students will have the rights, I'm not entirely, but I heard at this conference that in Sweden, students have the rights to their inventions, even in a university. In Estonia, I think the law is that they don't, that the university owns the rights. If you do something in a university project, in a class, then the law works in such a way that it's automatically presumed to be the university's. And that if the student goes out and uses this, then they're violating university laws. And in Estonia, that can mean not just civil penalties, but also criminal penalties, potentially. But I think in Sweden, one of the only countries in the world where they have created sort of this safe harbor that students get to keep the fruits of their labor. But the university often in Estonia shares these ideas or licenses it out or allows it to be shared. But I think it's still the actual right in a school project belongs to the school. Yeah.
I just wanted to ask that have the students signed this agreement that these author rights are
This is another interesting area of law. In America, I know that these things have been through courts. In Estonia, with its very, very short judicial history, very few things have ever made it to all the way up to the Supreme Court in Estonia, and vast majority of this has not been tested. But I can tell you, in America, generally the law with universities is that the contract between a university and a student is the collection and the compendium of the literature that get exchanged between the student and the university. One of the biggest books that you get in an American college is basically your course manual, where all the classes are together, like where do you eat, and then in the back there's about 100 pages of agreements, or, well, rules, let's say. There's various behavior rules, you can't drink if you're under 21, I don't know, guys' dorms, girls' dorms, there's all of that is in that book, and that's considered a contract between you and the university. That university promises you certain things in that book, and also says these are the rules that you have to abide by. It would be reflected in something like that. In Estonia, it might be much more complicated. I unfortunately don't know how this applies. It would be worthwhile to know what rules you're operating under. If you're a student and doing a startup, for example. But for example, one specific case and point in law, a presumption that comes from law, even if you don't sign agreements, is that employees' inventions are automatically transferred to the employer in Estonia. So anything you as an employee invent at work, you have no right to it at all, other than author's natural rights, okay? But it automatically, anything you invent at your job is not yours, because it's your job. You're getting paid salary to be inventing anyway. So anything that from your day job comes out, it's the employer's. Which is why it's so important when you hire contractors, they are not employees, okay? Contractors are not employees. Contractors are independent contractors, equal to the so-called employer. Therefore, that contract has to be explicit that the rights are being handed over, because the protection of the employer-employee situation does not apply, because they're not in a dependency relationship, employer-employee, but with a contractor, it's two companies making a deal. Okay, that's the difference in IP law going to an employee versus a contractor, which is why the documentation is so important. Of course, with employees, you've got this whole issue, which it always comes down to, in the end, they go, but I didn't write it during the day. I wrote it at night. And you're like, well, you know, where did you write it? Well, I was at work. Well, you wrote it on our computer, so it's ours. So you start to have these kinds of discussions. Worse yet, the person wrote it at home, but they're using their company laptop and maybe internet connection that the company's paying for, and maybe they're even getting some kind of home office. So really, their home office might also be their office. And this is why this gets so complicated. Skip it all. Don't get into discussions like that. Have a one-page agreement with your employees too that says, okay, the law says this, you know, everything gets transferred, and the agreement between you and me, aside from the law, is that anything that gets created in this entire time is the company's, or whatever agreement you want to agree into, or anything that gets created on this computer is the company's. But set your own rules so you're not, so you don't have to rely on the court to decide. Because the court, by the time you actually get in front of a judge, and it might be years, you can't, that's not operational in a software business, years. You know, you need, in a matter of days, you need answers right away, you know. So it's better to have something in place which specifically says what's the deal. Yeah.
I had a discussion with one of my legal buddies, and one.
See, lawyers have friends. You
yes,
heard it.
They have friends
right
sometimes.
There.
Yes,
he admits it.
Money has always friends. Okay, but the case was that they were in a gaming company, in a startup, and they had for the employees type of a rule that if you're gonna do something on your own, it's quite fine in the company premises, but please use your own hard drive, for instance, and take it away when you.
That's a very specific rule. It's always good when you do rules. It's always good to have something that. What happens when you don't? Or how do you measure? The hard drive is very simple. It either is on the hard drive or is not, okay? Very simple to verify. If you got to decide, you go to the hard drive, you check it, is it on there or is it not, and you have a solution. If you say, to be determined, a board will decide, if you set up that kind of rules, these are very amorphous, takes a long time, you get politics, it gets ugly. Better to have simple rules, very obvious simple rules. More? Comments? Last call? Last chance? Going? Gone. Okay. That concludes at least my portion of the theater for the day. You can do your own performances, pitches, etc., and networking. Meeting people after here. I think there's a little bit of coffee and some snacks, perhaps. No, we're scraping the bottom. Okay, it's been a long day. I hope you enjoyed it. I did not waste your time, I hope. And if you have questions, tweet me at Yrjö or email me, okay? Thank you.